And with me here in Washington, Chuck Rosenberg, former U.S. attorney and senior FBI official. He's also an MSNBC contributor. Chuck, we've been watching Nathan Wade, who Fani Willis hired to basically be the managing partner, if you will, of the prosecution. And his assertion and hers that their relationship, their romantic relationship that they had previously denied, started after he had begun working for her. There's conflicting testimony here, though, from a former associate.
Yes, that's exactly right, Andrea. There is conflicting testimony. A woman named Robin Yurti testified earlier this morning that she had been close friends with Fani Willis and that she knew, observed that Ms. Willis and Mr. Wade had a romantic relationship. And she described seeing, sort of the things that you might see when two people are dating, affection. Contrast that with what Mr. Wade just said on the stand, which was that they did have a romantic relationship, but it did not start as early as Ms. Yurti said it started. It started, to your point, after he was hired by the district attorney on a contractual basis to work on this case. So what does that mean? You have two different stories, X and not X. And now the finder of fact, the judge in this case, is going to have to make a determination based on testimony, on credibility, on his assessment of the witnesses, and perhaps on other witnesses yet to come.
And so far, he's been questioned by Michael Roman, a co-defendant of Donald Trump's attorney. Now, if the judge does decide that they're in this conflict, that Nathan Wade and potentially Fani Willis in her assertions, she may well take the stand as well, but in her assertions, the affidavit to the court, that if they misrepresented, basically lied to the court, do you think that, well, that would disqualify them, but do you think that there is becoming, as we watch this testimony and we're going to see more lawyers for these co-defendants, including Donald Trump, potentially questioning him and then a cross-examination. But if it's determined that they have apparently misled, even before the judge rules in this case, do you think we should reach a point where, for the interest of protecting the trial, the entire Fulton County trial, that they should voluntarily step aside?
It's a great question. So this is not going well for the state. It could turn out okay, and it might turn out worse. But I think a district attorney, a U.S. attorney, a prosecuting official has a special obligation to the case. In fact, I had grabbed some language from a 1935 Supreme Court case. I used to keep this excerpt from Berger v. U.S. on my desk when I was a prosecutor and when I was the United States attorney. I'm not going to read all of it, I promise, but I just wanted to read a sentence. The prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation is to govern impartially, and that obligation is as compelling as its obligation to govern at all, and whose interest, therefore, is not that it shall win a case, but that justice shall be done. Prosecutors have a higher obligation. It's not personal. It's not egotistical. It's not about you. It's about the office and the pursuit of justice. To your point, it might be appropriate for Ms. Willis to consider removing herself from this case now and turning the reins over to a senior official in the district attorney's office and let him or her handle it. Because this is getting ugly and it's getting messy, and my guess is it's not going to get better.